Imagine it's 1787, and the delegates from the 13 states have gathered in Philadelphia to address the weaknesses of the Articles of Confederation. There was a significant divide between the larger states, which favored the Virginia plan proposing representation in Congress based on a state's population, and the smaller states, which preferred the New Jersey plan advocating for equal representation for each state. The deadlock was intense, with larger states arguing that representation based on population was fairer, and smaller states fearing they would be overpowered in such a system. The tension was not just about representation, but also about creating a system where no single group or state could dominate the others, a fundamental aspect of the checks and balances system. The breakthrough came with the Great Compromise proposed by Roger Sherman and Oliver Ellsworth of Connecticut. This compromise led to the creation of a bicameral legislature, which we know today as Congress, consisting of two houses, the Senate and the House of Representatives. In the Senate, each state would have equal representation, 2 senators per state, satisfying the smaller states. In the House of Representatives, representation would be based on population, appeasing the larger states. This compromise was pivotal in shaping the checks and balances system. It created a balance of power within the legislature itself, ensuring that both large and small states had fair representation and that neither could dominate the federal legislature. And it laid the foundation for a broader system of checks and balances across the branches. By ensuring that no single state or group could control the legislature, it set a precedent for creating mechanisms to prevent any one branch of the new government from gaining too much power. That idea of checks and balances thus became a fundamental principle in the U.S. Constitution, whereby each of the 3 branches of government, the executive, legislative, and judicial branches, had some measure of influence over the other branches and may choose to block procedures from the other branches. This system is designed to prevent any one branch from gaining too much power and to ensure a balance in the government's functioning. The concept of checks and balances has historical roots in ancient Greece and Rome, but the immediate philosophical basis is found in the works of Enlightenment thinkers like Montesquieu and John Locke, who advocated for a separation of powers to avoid tyranny and protect liberty. They also draw on Native American tribal traditions, particularly those of the Haudenosaunee Confederation and the Great Law of Peace, which divided political authority between separate institutions in order to guard against the consolidation of political power by any one group or actor. The constitutional basis of the system of checks and balances can be found in the various articles establishing the federal legislative, executive, and judicial branches, reserving specific powers and responsibilities for each branch and granting each some powers over the others. Article 1 outlines the powers of the legislative branch, the Congress. Article 2 outlines the powers of the executive branch, the presidency. And Article 3 outlines the judicial branch, the courts. The legislative branch, comprised of the U.S. Senate and the House of Representatives, holds significant powers of checks and balances over the other 2 branches. With respect to the executive branch, the Congress has the power to pass legislation and enact federal laws, and can override a presidential veto with a 2/3 vote in both the House and the Senate. This power ensures that the president cannot unilaterally prevent the passage of legislation. Through its control of the budget, Congress can influence executive activities. No money can be drawn from the Treasury without legislative approval, effectively controlling and overseeing executive operations through funding. The Senate has the power of advice and consent, requiring it to confirm presidential appointments to the cabinet, federal judiciary, and other significant offices. In a similar way, it also has the power to ratify or reject treaties negotiated by the president. Congress has a variety of investigative and oversight powers. It can investigate executive conduct and issues of national concern, summoning witnesses and requiring the production of documents. And ultimately, the Congress has the power to impeach and remove the president, vice president, or other federal officers for treason, bribery, or other high crimes or misdemeanors. With respect to the courts, the Congress has the power to establish and organize all courts below the U.S. Supreme Court, including the ability to dictate the number of judges and jurisdictions of the courts. The Senate has the power to confirm or reject the appointment of all federal judges, including Supreme Court justices, ensuring that judicial appointments are subject to legislative approval. And Congress has the power to impeach and remove federal judges, including Supreme Court justices, for misconduct. In response to Supreme Court decisions, Congress has the power to propose constitutional amendments and override judicial rulings, though this is a difficult and rarely used power due to the high requirements for amending the Constitution. More often, Congress can pass new legislation to clarify existing laws or alter the legal landscape following a court decision within the boundaries of the Constitution. The executive branch is headed by the President of the United States and also has a series of checks and balances it uses to ensure it can influence or limit the powers of the legislative and judicial branches. Against the legislative branch, the President has the power to veto legislation passed by Congress. While not an absolute check, as Congress can override the veto with a two-thirds majority of both houses, it's nevertheless a powerful tool to prevent the enactment of laws the President opposes. The President can also make legislative recommendations, most often through the annual State of the Union address, giving Congress information on the State of the Union and recommending measures the President considers necessary and expedient. This can shape legislative priorities and the legislative agenda. And the President can call special sessions of one or both houses of Congress, particularly in urgent situations. As the chief law enforcement officer, the President has discretion in enforcing laws. This includes decisions about resource allocation and prioritization, which can effectively shape how laws are implemented and what aspects are emphasized. And through the use of executive orders and agreements, the President can act without congressional approval in some important, albeit limited ways. And against the judicial branch, the President's power to nominate judges to the federal judiciary gives them power to shape and influence the composition of the judiciary and thus its interpretation of laws over time. The President can also grant pardons and reprieves for offenses against the United States, except in cases of impeachment. This gives the President the power to forgive or lessen penalties for crimes, effectively overriding judicial decisions. And finally, the judiciary must rely on the executive branch to enforce its decisions, a fact that has sometimes led to tension between the two branches. Finally, the judicial branch, primarily through the Supreme Court and other federal courts, also plays a role in the system of checks and balances in the U.S. government. The primary and most powerful tool of the courts is the power of judicial review, through which the judicial branch interprets laws and, when necessary, declares acts of Congress unconstitutional. If a law is found unconstitutional, it's nullified and cannot be enforced, effectively checking legislative power. And more broadly, the federal courts have the power of statutory interpretation, or the ability to interpret the meaning and application of laws, determining how they should be applied in specific cases. Through these interpretations, the courts can influence how laws are understood and implemented, shaping their effect and scope. And just as it can with the Congress, so too can the courts exercise the power of judicial review over executive actions, reviewing the activities, orders, and regulations of the executive branch and deciding whether or not they are constitutional. The courts also exercise the oversight of administrative agencies, reviewing the decisions and rules made by many federal administrative agencies to ensure they comply with the law and do not overstep their authority. More broadly, the life tenure and salary protections afforded judges ensures they retain a degree of autonomy from other branches. Federal judges, once appointed and confirmed, typically serve for life unless they resign, retire, or are impeached or removed. This lifetime appointment, coupled with protections that their salaries cannot be diminished during the continuation of office, ensures that judges can decide cases free from direct political pressures, serving as an independent check on the other branches. And the ability of the courts to issue temporary halts to executive or legislative actions can prevent potentially unconstitutional laws or actions from being implemented until a full review is conducted. But it's important to note that unlike the other two branches, the judiciary's checks and balances are primarily reactive, only coming into play when a case is brought before the courts. Unlike the legislative and executive branches, which can proactively pass laws and issue orders, the judiciary typically responds to specific disputes or challenges. However, through these responses, it nevertheless exerts profound influence, ensuring that the United States remains a nation of laws with a government that operates within the bounds of the Constitution. We can explore the Affordable Care Act, commonly referred to as Obamacare or the ACA, and see this system of checks and balances in action. The Affordable Care Act was passed in 2010 after extensive debate and negotiation in Congress. The act was designed to extend health insurance coverage to millions of uninsured Americans, among other provisions. The legislative branch exercised its power to create and pass legislation, demonstrating its role in initiating laws that address national issues. Once passed, it was up to the executive branch under President Obama to implement it. This included setting up healthcare exchanges, expanding Medicaid, and enforcing new insurance regulations. The executive branch's role was to ensure the law's successful implementation and to manage federal agencies responsible for its various components. The ACA's constitutionality was challenged in the courts almost immediately after its passage. The most significant aspect of this challenge was the individual mandate, a provision that required most Americans to have health insurance or pay a penalty. Opponents argued that this exceeded the Congress's powers under the Commerce Clause and other parts of the Constitution. When the ACA was challenged in the courts, the executive branch, through the Department of Justice, defended its legality. This is a standard role of the executive branch, defending and upholding laws passed by Congress that face legal challenges. In its landmark decision, the Supreme Court upheld the majority of the ACA as constitutional. However, the reasoning was significant. The court, led by Chief Justice John Roberts, ruled that while the individual mandate was not valid under the Commerce Clause, it could be considered a tax, which is within Congress's power to impose. This preserved the bulk of the ACA while interpreting the extent and limits of legislative power. Additionally, the court ruled that the expansion of Medicaid was constitutional, but that it would be unconstitutional for the federal government to withhold existing Medicaid funds from states that refused to participate in the expansion, thus limiting the power of the federal government and ensuring states' rights. This case exemplifies the system of checks and balances at work, with all three branches interacting. The legislative branch passed a significant law, the executive branch worked to implement it and defend it, and the judicial branch reviewed its constitutionality, setting limits and interpretations on its provisions. It's a clear illustration of the system designed to ensure that no single branch of government becomes too powerful while still allowing for effective governance. While it's been fundamentally important in maintaining democratic principles and ensuring functioning government, the system of checks and balances is not without its critiques or challenges. First, the need for multiple branches to agree on a course of action can lead to significant delays in lawmaking and policy implementation. Particularly when the branches are controlled by different political parties, this can result in gridlock, where very little is accomplished due to constant blocking and vetoes. And while the Constitution provides a broad outline of each branch's power, it doesn't detail every scenario. Over time, this has led to disputes over the extent and limits of each branch's authority, sometimes resulting in power struggles and constitutional crisis. Further, as laws and societies become more complex, the interplay between the different branches' powers can lead to inconsistent or conflicting interpretations and applications of the law, creating legal and administrative complexities. Increasingly, political parties have used the mechanism of checks and balances not just to maintain the institutional balance, but to thwart the agendas of the opposing party. This can lead to a breakdown in collaboration and heightened partisanship, where the focus shifts from good governance to political victory. There are also instances where branches may overreach or underutilize their powers due to political pressures rather than constitutional principles, leading to imbalances and potentially undermining the system's integrity. And within the system of checks and balances, critics argue that the modern presidency has become too powerful, with increased use of executive orders, emergency declarations, and control over the military and foreign policy. Further, the power of judicial review can lead to what some see as judicial activism, where the courts are effectively creating policy through their rulings, or excessive use of judicial restraint, which can lead to unchecked powers from the other branches if the courts are too deferential. Finally, the system was designed over 2 centuries ago, and some argue that it hasn't adapted well to the modern complexities of governance, global interconnectedness, and technological advancements. There are ongoing debates about how to update or reform various aspects of the system to make it more efficient and responsive and in tune with contemporary needs while still preserving its fundamental checks. But that's it for now. As always, please leave any questions you have in the comment section below, and thanks for watching.